Hello and welcome. Today I'll be introducing Contract Act 1950, Part 3, War and Natural Disasters. Section 57 of the Contracts Act 1950 codifies the doctrine of frustration in Malaysian contract law. It states that a contract to do an act which, after the contract is made, becomes impossible or unlawful due to events beyond the control of the promisor, becomes void. This provision is crucial in addressing situations where unforeseen events such as war or natural disasters render contractual obligations impossible to fulfill. The doctrine of frustration ensures that parties are not held liable for non-performance when circumstances change drastically and beyond their control. It provides a legal mechanism to void contracts that have become impracticable or illegal to perform, thereby protecting the interests of both parties involved. This section is particularly relevant in cases where supervening impossibility arises, such as government-imposed restrictions or environmental catastrophes that disrupt the ability to carry out contractual duties. War and natural disasters are recognized under Section 57 as valid grounds for frustration. In the case of war, performance may become impossible due to export bans, destruction of trade routes, or the illegality of dealing with enemy states. Malaysian courts have acknowledged war as a frustrating event when it directly impedes contractual performance. Natural disasters, including earthquakes, floods, tsunamis, and pandemics, can also frustrate a contract if they make performance impossible or radically different from what was originally agreed. For instance, a factory destroyed by a flood before it can deliver goods, or government lockdown orders during the COVID-19 pandemic preventing businesses from operating, are examples where courts have treated such impossibility as frustration under Section 57. These events must be unforeseen and not self-induced, and they must fundamentally alter the nature of the contractual obligations to qualify as frustration. Force majeure clauses in Section 57 operate differently in Malaysian contract law. If a contract includes an express force majeure clause that covers events such as war, natural disasters, or epidemics, courts will prioritize and apply the clause because it reflects the parties' intentions. These clauses provide a predefined framework for handling unforeseen events and typically outline the procedures and consequences of invoking force majeure. However, if no such clause exists, parties must rely on Section 57, which automatically applies when performance becomes truly impossible or unlawful. The application of Section 57 is strict. Mere increased cost or difficulty does not suffice. The event must render the performance fundamentally different or impossible. This distinction is important because it determines whether the contract is governed by the parties' agreed terms or by statutory provisions. Understanding the interplay between force majeure clauses and Section 57 is essential for drafting resilient contracts and for legal recourse in the face of disruptive events. When a contract becomes void under Section 57 due to frustration, Section 66 of the Contracts Act 1950 mandates restitution. This means that any advantage received under the contract must be restored. For example, if deposits or prepayments were made before the frustrating event occurred, Section 66 requires that these amounts be refunded, subject to equitable considerations. The contract is considered void only from the point of frustration onwards, not retroactively. This ensures that parties are not unjustly enriched and that fairness is maintained in the aftermath of a frustrated contract. Restitution under Section 66 is a critical aspect of the legal framework, as it addresses the financial implications of voided contracts and provides a remedy for parties who have incurred losses due to unforeseen events. Courts assess the situation to determine just compensation or restoration, ensuring that the outcome is equitable for all involved. Two notable examples illustrate the application of the doctrine of frustration under Section 57 in Malaysia. The first is the case of Yew Siew Hoo v. Nikmat Maju Development SDN Bhd, where a serious outbreak of Japanese encephalitis, JA, led the state government to declare the affected area infected and ban the rearing and sale of pigs. This directly impacted a tapping and related service agreement in that area. The High Court ruled that the contracts were void due to frustration, as the JE outbreak made performance impossible and unlawful under Section 57. The decision was not appealed, making it a clear precedent for frustration caused by statutory prohibition following an unforeseen health crisis. The second example is a hypothetical illustration often used in legal commentary. Agrees to transport cargo for B at a foreign port, but after the contract is signed, A's government declares war on the country where the port is located. The contract becomes automatically void because performing it has become impossible or unlawful due to the war. These examples demonstrate how sudden events like disease outbreaks and geopolitical conflicts fulfill the criteria for frustration under Malaysian law. To successfully claim frustration under Section 57, Malaysian courts often refer to the three-pronged test established in Guan Aik Moh, KL, SDN Bhd v Selangor Properties Bhd, 2007, for MLJ 201. The test includes, 1. No provision in the contract for the frustrating event, meaning the contract does not anticipate or provide for the occurrence of the event. 2. The event is beyond the control of the contracting party, indicating that it was not self-induced or foreseeable. And 3. The event renders performance radically different from what was originally undertaken, emphasizing that mere hardship or increased expense does not qualify. This legal framework ensures that frustration is applied strictly and only in cases where the fundamental nature of the contract has been altered. It protects the integrity of contractual obligations while providing relief in genuinely impossible situations. Understanding these criteria is essential for legal practitioners and contracting parties to assess the viability of frustration claims and to structure contracts that anticipate potential risks. Once a contract is voided under Section 57 due to frustration, the legal consequences are governed by Section 66 of the Contracts Act 1950. The contract is considered void only from the point of frustration onwards, meaning that obligations prior to the frustrating event remain valid. Section 66 mandates restitution, requiring parties to restore any benefits received or to make compensation as deemed just by the court. This ensures that neither party is unfairly enriched or disadvantaged due to the voided contract. The principle of restitution is applied equitably, taking into account the circumstances and the extent of the benefits conferred. Courts may order refunds of deposits, reimbursement for services rendered, or other forms of compensation to balance the interests of both parties. This legal mechanism provides a fair resolution to contracts disrupted by unforeseen events and reinforces the importance of equitable treatment in contract law. Malaysian law recognizes war and major natural or man-made disasters, such as disease outbreaks, as valid grounds for frustration under Section 57 of the Contracts Act 1950. These events must render contract performance impossible or unlawful to qualify. The Yew Siew Hoo case serves as a prime example of frustration due to a health crisis, while the war hypothetical illustrates how geopolitical events can void contracts. If a contract includes a force majeure clause, it will govern the outcome, reflecting the parties' intentions. Otherwise, Section 57 applies, subject to a strict legal test. The event must be unforeseen, not self-induced, and must fundamentally alter the contractual obligations. Section 66 ensures restitution, requiring parties to restore benefits or compensate as deemed just. Understanding these provisions is essential for drafting resilient contracts and for navigating legal remedies in the face of disruptive events.
If you like our content, kindly like, share and subscribe.